Well, welcome to the ERA Today. This is a forum brought to you by the League of Women Voters of Dane County. We will be recording this forum to post on the League's website after we're finished. I'm Joy Cardin. I'm a retired talk show host at Wisconsin Public Radio. I'm a member of the League of Women Voters of Dane County and the League of Women Voters of Wisconsin's Board of Directors. The Equal Rights Amendment reads, equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. Pretty simple. Congress passed the ERA in 1972. By 1982, only 35 states had ratified, 3 shy of the necessary 38. But then everything changed in 2017. Nevada ratified the ERA. It was the first state in 40 years to do so. And one of our guests tonight, Janette Dean, played a big role in that success. We'll hear about her experiences and why she is so passionate about adopting the ERA immediately. The Nevada ratification started the ERA ball rolling again. Illinois ratified it in 2018. Virginia ratified it in January of this year, becoming the 38th and presumably the final state that was needed. But because these ratifications came more than 30 years after the 1982 and already once extended deadline, and 5 states passed resolutions to rescind their approval, and the U.S. Archivist has not certified the Virginia vote, and the U.S. Senate has not followed the lead of the House of Representatives and acted on legislation to remove the ratification deadline, there are many hurdles that still need to be overcome. We'll discuss those legal hurdles to the ERA a little bit later in our forum with Joan Schwarz, who is a retired attorney who taught gender law and policy classes at the University of Wisconsin-Whitewater. And then we'll welcome your questions and your thoughts for both of our guests. Let me introduce our first guest, Janette Dean. Janette was born in Milwaukee and raised in La Crescent, Minnesota, near La Crosse. She is an alumna of the University of Southern California and the University of Nevada, Reno. She has a dual BA in political science and sociology. While in Northern Nevada, Janette led a 3-year statewide grassroots effort in Carson City, working with legislators to achieve the state ratification of the Equal Rights Amendment. That was on March 22nd, 2017. This made Nevada the first state to do so since 1977, which helped revive the national movement. Hello, Janette. Thank you so much for joining us tonight. We'll need you to unmute your microphone as well. So we'll need Janette to be invited to unmute her microphone.
Now it works. Wonderful. Thank you, everyone. Such a pleasure to be here. We have so much to celebrate as we move forward in progress for our much overdue Equal Rights Amendment. So I am glad to be here and to share where we're at and where we're going.
So, Janette, you are you're wearing Equal Means Equal. This is a sash, a banner that you wore when Virginia had that historic vote. I saw you in a photograph with that sash on. Talk a little bit about that. Equal means equal hints that we aren't equal yet. Women do not have equal rights yet. Why do you think the ERA is still needed today?
Yes, very unfortunately, there's only one equal right in our Constitution, and that is the equal right to vote. You would think that the 14th Amendment, which provides equal protection of the laws to every person in the United States, would provide equality if that was being interpreted in a just way. But unfortunately, there's something in the law that is called strict scrutiny of discrimination versus skeptical scrutiny or intermediate scrutiny. And when women have come forward with very important discrimination cases, they've been denied victories because the judges at the Supreme Court level are applying intermediate scrutiny, skeptical scrutiny. And that's not true when it comes to persons' race, national origin, religion, and other what they call suspect classifications. So some of the types of lawsuits that women are losing because we don't have the word discrimination shall not be denied or abridged on the account of sex is not in the Constitution, except for the equal right to vote. That will change with the Equal Rights Amendment. It'll provide stop discrimination on any right in the Constitution.
In specific examples, though, Janette,
yes.
A lot of people think, hey, women have equal rights right now. There's no, besides
Sure.
these legal grounds you're citing, what are some of the examples of discrimination that still exist today that
Sure.
require an equal rights amendment?
Well, I'll be happy to explain that. There was Equal Means Equal, who you mentioned. That is a group based in California. They created a film that highlighted some of those many areas where women are still suffering immense harm from discrimination. And in the video, they had many bubbles of all the ways that women are being discriminated against. And some of these are in the areas of violence against women. When it comes to rape, murder, sexual assault, a lot of times police are not taking women's complaints seriously in going to their protection, or they are incarcerating them when really they're victims of crimes such as prostitution, or if they're on college campuses, they're suffering severe harassment at times, again, as well as violence. So just the fact that their lives are constantly at risk because not enough is being done to protect women from these violent crimes. And again, that doesn't just hurt the particular woman, that hurts her family, of course, other female members in her family, but of course, other male members in her family, her brothers, her husband, her children. So equal rights matter to all of us. So beyond the violent areas that are extremely egregious in our ability to have full and functioning lives, poverty is another area. There's been a lot of discrimination in hiring, promotion of women for decades. And luckily, we have been breaking those glass ceilings, but that's not certainly true for all women, especially women of color are often discriminated against in hiring and in promotion. And that income affects their lives in very significant ways. It limits what they're able to achieve in life, what types of head starts their children have, if they're in poverty or not. Another area would be reproductive health care. Women need reproductive health care to have family planning, to live full lives and be able to plan their families. There's been too much discrimination in education, in equal provisions of birth control and planning methods. And then when the woman's health is at risk with perhaps a complicated pregnancy, many have been using very extremist arguments to limit the protection of the mother when a pregnancy is going very, very wrong.
And I know,
So-
Janette, we could go on and we could go
Yes,
on for the whole
those are
hour.
a few.
We thought that this could happen with just listing some of the
Yes.
examples and the reasons why you believe the ERA is still needed today. But let's get a little bit into your work in Nevada when you formed Nevadans for the ERA. Tell us what motivated you to do that and how you managed to get this passed.
Okay, certainly. Well, I, like a lot of Gen Xers, the Equal Rights Amendment hasn't been on our radar. The women before us put up a very strong fight for the Equal Rights Amendment, and they were limited time and time again, and it fizzled out in some of the decades of the 80s and 90s. And therefore, some of the newer generations of women they thought it was part of the Constitution. It was never really explained in a lot of history classes that our Bill of Rights does not protect women. We all learn our Constitution, but not a lot of us learn about the missing amendment. So when I was in college in the University of Nevada, Reno, I'd been studying international human rights at the highest levels globally. And at that time, I didn't even realize that our Constitution didn't yet protect us. But I was working at the legislature as part of my internship for my poli-sci degree. I did a 20-hour internship, and I began to work with legislators on all types of bills, renewable energy bills, mammogram bills, Citizens United, a lot of important bills and resolutions that needed to be passed. And it happened that was 2013. And the summer afterward, in 2014, there was a woman crossing the country. Her name was Helene de Boissier Swanson. And her mother-in-law's dying wish, she was part of the movement for the Equal Rights Amendment. She said, Helene, and to the son, my dying wish is that the Equal Rights Amendment is revived and it continues. So Helene took that to heart. And in 2014, she studied the states that had failed to ratify. And she decided to do a pilgrimage on foot to every single one of the 15 states that hadn't ratified. And leaving from San Francisco on International Women's Equality Day, she headed for Nevada. And the first capital she got to was Carson City. And she had called the Carson City Democrats and said, I'm interested in working with one of the top organizers in the area who can help me revive the fight. And they immediately thought of me because I'd been doing a lot of work in Carson City through protests in the streets against foreclosures and Black Lives Matter. And as I said, indeed, inside the legislature on laws. So they set up a call to me and asked if I'd meet with Helene. And when Helene told me that we ourselves in the US had never ratified the ERA, it blew my mind. And I realized that just the previous year, we had had the numbers in the legislature to have passed the resolution, but it wasn't on anybody's to-do list. The last attempt had been in 2009, and they were stymied by a majority that wasn't willing to hear the bills in the Senate. So I got to work that exact summer. I solicited the support of Harry Reid, first of all, who was visiting UNR, as well as other top leaders in the state and organizations. And then I solicited the help of a very wonderful Senator Spearman, a woman of color who I had worked with and who was very strong. And I knew we'd make a great team. And we pushed it in 2015. We didn't have the numbers that year after a midterm election, but we brought it back in 2017. And we were able to ratify it after a lot of rallies, newspaper articles, calls, petitions, and so on. So as my dad taught me, the squeaky wheel gets the oil, and if there's a will, there's a way, as my mother taught me. So I was very happy that I was in the state during that time to be able to accomplish this with many others.
Well, for time's sake, I'm going to fast forward to January, because I know that you were also, you went to Virginia for that historic vote. Tell us a little bit about what you did there and what that was like.
Certainly. So after Nevada ratified, we knew we couldn't quit. We said we're going to help other states continue. And in fact, they've been supporting Nevada's effort. Virginia even sent us the original 1970s buttons that said ERA yes to inspire us. So we were sharing the love nationally as well for the ERA. And in 2018, we were able to help Illinois pass it. I did a lot of calls, social media work, and reach outs, and asked Senator Spearman to please go there and help convince Illinois legislators on the importance of this. And it wasn't easy because they needed a larger majority than 51%. But during the vote on the floor, they actually were able to pass it in 2018 on May 30th. So that's when we moved our sites to Illinois. And Illinois tried very hard in 2019. I was again on social media, calling, helping, but they just didn't have the numbers and they were stimmy. So what they did is similar to what we did in Nevada. We got out the vote for legislators and candidates who would vote for it, and we made it in an election issue. So in January, like Nevada, after they'd been stymied, it was the first bill out of the gate, and it was named House Resolution 1 and Senate Joint Resolution 1. That shows you how important it was to the entire Virginia legislators' new Democratic majority. And so we continued to do calls and rallies, and they passed it out of both houses January 15th, and then there needed to be concurrence in both houses. So I traveled during the final 10 days to root them on and to show that this wasn't just a Virginia issue, this was a national issue, that Nevada was counting on them. And I was able to provide testimony that not only was it important again to Virginia citizens, but Nevada, and now that I live in Minnesota and I'm born in Wisconsin, that our states cared about this, and so did Illinois. So we were able to pass it on January 27th through both houses to become the 38th needed state to ratify, because rescissions have never been allowed.
That really must have been a thrill, but that wasn't the final hurdle, and this can get complicated too, but the U.S. Archivist did not certify the Virginia vote. How frustrating was that?
That was very frustrating because the previous archivist under President Barack Obama had certified both Nevada's ratification and Illinois' ratification. But when it came to the 38th state under a new administration, David Ferriero, the current archivist, decided to seek the Department of Justice's opinion. And with a very partisan opinion, they decided that no, they would not recognize the spirit of the law that Congress had meant the ERA to pass. In fact, when Congress passed it, they passed it with a very overwhelming majority of 354 votes to 24 and 84 votes in the Senate against 8. And here's what happened. Beginning in Prohibition, they decided amendments should move along a little bit faster. And it was only then that Congress started adding 7-year deadlines. And normally it wasn't a problem. States were passing amendments in sufficient time that it never crept up. But when it stalled with the ERA at just 35 states, by 1979, 77, they'd had 35, and by the deadline, the 7-year deadline in 79, they couldn't get the 3 additional states. Congress did grant a 3-year extension, again thinking that would be sufficient. So the archivist and the Department of Justice should have understood that Congress was in full support, and with the ratifications, it should continue to be certified. But they said the deadline had passed. So now luckily, we have other lawsuits. And as you know, the Senate is also getting ready in the next session, if they have the majority, to lift the deadline. So we've got a lot of options, and I know we're going to discuss those a little further.
Yeah, and we will get into a little bit more of the legal and constitutional issues with Joan in just a minute. But do you have any advice for advocates of the ERA that might be with us tonight on how we can help get the job done?
Yes. Well, first of all, I want to say that the U.S. has already promised equality at the global level. So even without the ERA, the national government should be taking this up at the Department of Justice, Congress, through executive order. The Universal Declaration of Human Rights, which Eleanor Roosevelt chaired the drafting committee, it's clearly written in the preamble that all women and men shall have equal rights. So simply by being an adopter of that 1948 declaration, we're beholden to provide equal rights for men and women at the national level. Beyond that, we also have the Sustainable Development Goals. And just again, in 2015, right here in New York City, as a member of the UN General Assembly, the U.S. again agreed that it would support and provide goal number 5 out of 17, which is gender equality. So we have international laws that require us to provide equality. So the ERA is the easiest method to do that. It's not the only, but we should keep pushing. So keep pushing on senators, Congress people, just as we've been doing, signing petitions. And the next president has already shared support. If it's Joe Biden and Kamala Harris, you can be assured they'll be working very hard for this. If it's anyone else, we have to keep pushing on them. And again, it may take getting out in the streets and not celebrating women's equality without outrage as well, that we only have one equal right in the Constitution, and that's intolerable. I know that men would never tolerate it if they were only provided one right, but usually their rights are upheld. But the Equal Rights Amendment will provide them more protection in the rare cases when they are discriminated by sex, such as in a child custody case, such as when they want to work in a more traditional woman's field. So it works both ways, but women are by far the ones who need it the most right now, but it will help everyone.
Let me ask you one final question, and I'm sure we'll have more questions at the end. Supreme Court Justice Ruth Bader Ginsburg, a longtime advocate, as you know, of the ERA, said in an interview earlier this year that instead of continuing this route, this ratification battle, it might be better to just start all over from scratch. I know the ERA coalition disagrees with this, and so do you. Very briefly now, because we need to move on. We've got so much territory to cover. Why not start over?
Well, I honor and respect RBG, as we so affectionately call her. And it really shocked us that she would ever say something like this. It's leaning on a technicality that doesn't respect the spirit of the laws or the spirit of all the commitments and promises our country has made. So I disagree with her, as you know, and I think if she thought this through, she would realize this is a life or death matter. We just cannot spend decades and decades again fighting for this against a very extremist group that's fighting tooth and nail to prevent this. So as you asked, we will continue to fight for this. We will continue not starting over. There's just too many who would stop us, not just for years, but potentially decades. That's not right. We are 51% of the population. When laws are unjust, it is our ethical right to break those laws, to change those laws, and to not tolerate unethical technicalities that keep us as second-class citizens. It wouldn't be tolerated with any other type of, let's say slavery was continued. Never could you say, oh, go back to the drawing board and start over. It's just far too unethical. It isn't like the 27th Amendment that was finally passed after 204 years that would say that congressional pay raises take place the next session. Now, they put that in the Constitution after 204 years. So I say, let's not tolerate technicalities that keep us as second-class citizens.
All right, thanks, Janette. We are going to talk more in depth now about the legal issues surrounding the ERA with Joan Schwarz. Joan is a Dane County League member and board member. She's a retired attorney who also taught gender law and policy classes at the University of Wisconsin-Whitewater for 30 years. Thanks very much, Joan, for lending us your legal expertise tonight.
Glad to be here. Thank you.
Let me ask you, because we just talked about Supreme Court Justice Ruth Bader Ginsburg saying that she believes that the proponents of the ERA should propose a new amendment and not try to get the current one certified. Can you explain the reasons why you believe she feels this way?
Yes. The distinction that's going on here is the distinction between policy proposals and legal decisions and precedent. There are four issues. There's the deadline issue, there's the rescission issue, there's what's called a political question doctrine issue in the law, and we already have a lawsuit pending with all of these issues, which I'll get to shortly. Just a little background on Justice Ginsburg. She has been the biggest champion for women's rights. Back in 1971, she argued a case when she wasn't obviously a justice. She was an attorney. She argued a case called Reed versus Reed, where basically the law was that women couldn't probate a case for their son. And she took that case all the way, and it ended up at the Supreme Court. And that's when the intermediate level of scrutiny was established. There had been, now just to explain a little bit further, the standard of review that the court uses is how close is a statute designed to its purpose without having any discrimination in it. And the rational level, the lowest level, pretty much almost all state statutes go through without much of a problem. The strict scrutiny was there, and it's always been mostly for race cases, because it's very clear with race cases. There's not the ambiguity. There's a lot of we've already know this with the ERA, a lot of different views about women and where they fit in society. And so sex issues have never reached the strict scrutiny level. It's clear, I think, that if we ever got this Equal Rights Amendment, we might be able to get sex looked at on a strict scrutiny basis, just as race is. But we're not there now, and from 1970, it hasn't happened in 50 years. The Supreme Court does not look at sex issues with strict scrutiny. Now, Justice Ginsburg, and I might just want to make a thing about the fact that a number of things, there is a lot of protection for women in discrimination cases in Title VII, which is a federal statute, and there are protected groups there, and women are protected there, and that has its own history. We're talking, though, about the amendment. Now, the timeline is a really important issue. Now, the 7-year deadline was placed in what's called the proposing resolution. That's the introduction to the text of the Equal Rights Amendment. And it was not placed in the text of the Equal Rights Amendment. And Janette's reference to the 27th Amendment is that proponents that say that we should not start all over, say, after all, that was passed into as an amendment after 203 years. And so, and they argue that because the timeline was not in the text, and they're saying the ERA timeline is not in the text. So after all, if the 27th Amendment went through after 203 years, so should the ERA. But that is not what we have as a history, because the whole timeline, and I'm going to back up just a minute. These are the reasons that I think Justice Ginsburg is asking it to start all over again. She understands the legal hurdles, and there are quite a few of them. And when I get toward the end, I will explain about the lawsuit that was filed in January that is literally encompassing all the legal challenges that will exist once and if the Senate ever passes it, even if we get a change in administration and the Senate passes the Equal Rights Amendment that we now have, it's going to more than likely be years in the court. Now,
talk a little bit more about that, Joan. So if the Senate would extend the deadline or follow the lead of the House, there are going to be many legal challenges facing the ERA.
And one of the first ones will be this timeline issue, because it's in the proposing statute. Now, what's interesting is, and these are the arguments that have been already leveled in this lawsuit. Now, the lawsuit is Commonwealth of Virginia and the state of Illinois and the state of Nevada have followed it. And I'll go into more about that in a few minutes. But the point is that the proponents of the present ERA are saying, well, this timeline in the proposing resolution, that's just legislative. We can change it. Congress can do whatever they want. There's some history here that needs to be taken into consideration. When this timeline was put in the proposed resolution, Nobody argued about it. They said it was innocuous, it didn't matter, that was just like a customary statute of limitations, wasn't a matter of substance, and didn't need to be concerned about it. Then there were all these attempts to get it moving. There were 56 joint resolutions proposing the ERA, and the timeline was always paced in the proposing resolution. And so we have this issue about the fact that the argument that it doesn't matter that it's a proposing resolution is really not going to hold much water, frankly, at the court. Now, the certification issue is very important because I might back up a little bit. What happened is after the archivist accepted the ratifications from Nevada and Illinois and then refused the ratification for Virginia, it went to the Department of Justice, and we know that that's under the executive branch. And essentially, they asked for what's called the Office of Legal Counsel opinion, and it's abbreviated as the OLC opinion. And you probably have heard about it when the whole Mueller study went on. The idea was you couldn't indict a sitting president, and that was an OLC opinion that was issued from the Department of Justice. So the archivist decided that he would get this OLC opinion, and the OLC opinion said, no, the statute is dead. I mean, the amendment is dead, and it can't go forward, and he wouldn't certify it. Now, the argument there can be, well, possibly with a different administration, we might get a different OLC opinion. The opinion handles every one of the issues that I am talking about, and handles it in quite a bit of depth in terms of the entire history of the amendment. One of the arguments is this three-state strategy that didn't happen until the 1990s doesn't fit with the history of what has been going on previous to it. But the main part of the argument of the OLC is that it allowed the 3-year extension to go through because the deadline was still pending. The 7 years wasn't up. But that there is no authority under Congress to change a deadline after the deadline has expired. And that's exactly what's being asked of right now. And so the archivist has taken the position, essentially, that despite the fact that Virginia has gotten the ratification, they're not moving until they get a federal court order, and that's why it's ending up in the federal court. So when Ruth Bader Ginsburg talks about the fact that she thinks we need to start over, she knows what's ahead because she's been an advocate for equal rights the entire time. It's been her life's work, but she also knows exactly how the legal system works. And all the policy arguments that Janette put forward are really important policy arguments, but they're not legal arguments. And that is the big distinction. Now, another issue that will be approached is the rescission issue.
Right.
The rescission issue, essentially, the proponents of the ERA is saying, it's okay, they rescinded, and as a result, we can just not worry about them. But there's precedent again. There was a case on this case, and it was Idaho rescinded, and it rescinded back in 1979 and took it to court, and it reached the Supreme Court, and the Supreme Court essentially mooted the case. They sent it back. They had asked for a declaratory judgment saying that their rescission was legal, valid. And the Supreme Court ended up sending it back down to the district court and said, it's not valid, the case is mooted, and the case was dismissed. Now that precedent from Idaho is still sitting on the books. So when the proponents of the ERA argue that it can be dismissed, precedent can be overruled, but it can't be ignored. It'll have to be dealt with, again, in lawsuits. The reason the Supreme Court dismissed or found the Idaho rescission valid was at that point they said, there aren't, when you take out the rescission, you have to replace it with another case that has ratified it. And so even there's this whole argument that says even if the rescissions were considered valid, there still weren't 5 more cases to replace the rescinded 5 cases. So the whole thing is that district court and Supreme Court opinion in the Idaho case is extremely important. Now, there's yet another issue, which is a pretty big issue, and that's called the political question doctrine. And this is a doctrine that's used at the Supreme Court, which means that it's really, the purpose of it is it's a function of the separation of powers. And it's essentially saying we will not allow our judicial system to do inappropriate review where it's not necessary. And once again, there's precedent from 1939. It was a child labor amendment, and it was proposed for ratification in 1924. And the Supreme Court literally, it's almost like we're not touching it. I mean, this happened during the Vietnam War. I mean, there are a number of reasons when the Supreme Court will use the political question doctrine and not make a decision on the case. It's often done in foreign policy. It's done, the organization of states' government is defined by their own constitution, and it is done with the ratification of constitutional amendments. So it would not be unusual for the Supreme Court to say, this is a political question, we're not making a decision. That shunts it back to Congress. So it depends on what, of course, Congress would do. Now, I can go a little bit into the lawsuit that has been filed. As I said, it was filed by the Commonwealth of Virginia, the state of Illinois, the state of Nevada, and it's against the archivist, David Ferraro. Now, when this was filed, President Trump immediately said he wants the Attorney General to get the lawsuit dismissed. Now, it's 8 months, and we have a docket in the legal system, and the docket just outlines every single thing that's been filed. It's pages and pages and pages long. It gets into what the first kick at the can, or what we call trying to get the case dismissed. And the first one is a summary judgment that says to the judge, there's no factual matter here. It's just a matter of law. This can be decided because there's nothing left to dispute factually. So the plaintiffs, the 3 states, have filed for a summary judgment, and they have argued that the timeline is valid and the ratification is a one-time event, and that the archivist has no discretion to deny certification. Then David Ferraro, the archivist, the defendant, he's filed what's called a motion to dismiss, which is just like a summary judgment in some ways, but saying that, there's no factual evidence here, you can make a decision on the matter of the law. Now, he is totally relying on the Office of Legal Counsel opinion that says the ratification, certification, the 3-year extension could take place before the 7-year deadline expired, but you can't get an extension after the deadline is filed. They're also relying on the Idaho case on rescission, so they're relying on that precedent. And the David Ferraro is also arguing the political question. Now, interestingly enough, added to the case, we have something called interveners, and other states have now joined the lawsuit. So Alabama, Louisiana, Nebraska, South Dakota, and Tennessee have also filed a summary judgment motion, and they are arguing precedent from a 1921 case on the 18th Amendment about prohibition, that it was timelines were okay. It is also even arguing that even if the 38 states were ratified, that those states have replaced the 5 that rescinded. Interestingly enough, these interveners are not arguing for the political question. They're saying, no, Supreme Court, you better make a decision on this, and this is inside your jurisdiction. Now, in addition to the plaintiffs and the defendants and the intervener defendants, Friends of the Court briefs get filed. And Friends of the Court are called amicus curiae briefs, and they are filed almost all the time in big deal cases. So one of the amicus briefs is by constitutional law professionals, and they absolutely argue the political question doctrine. They basically throw it back and say the court has to deal with this, not the courts. And they make a really strong argument about the fact that neither the archivist or the president has any role in making constitutional amendments, that the role of the archivist is merely ministerial, and that the executive branch, because it's political, literally needs to stay out of this, and the proper decision maker is the political branch. So we have the whole idea that with the political question doctrine, that the judiciary is not a majoritarian branch. It's not been elected. Well, the lower courts are, but not the upper court. Has not been elected, so it's not subject to the majority will. Another set of Friends of the Court briefs have been filed, and this is a really interesting one. This has been filed by 107 businesses. Some of the businesses are Apple, Citigroup, CVS Health, Google, Levi Strauss, MasterCard, Microsoft, National Football League, National Women's Soccer League, Pepsi, Uber, Twitter. And they're arguing, their entire brief is policy. Their entire brief is about the fact that as corporate citizens, they are arguing for persistent gender-based inequality to be overturned. They are arguing about employment disabilities, including pregnancy, what Janette talked about, sexual and intimate partner violence and rape, insufficient access to health care, especially now with COVID, maternity mortality, and economic burden and poverty. And essentially, they literally, and this is the plea that they're putting in their policy brief, they want a federal principle. They want a federal constitutional amendment that they believe will provide a clear judicial standard. And it would provide a clear judicial standard and is obviously very needed. But what we have here now is the balance between what the court normally does and how it operates in terms of it's not an outcome. It's not supposed to be. Sometimes it is, but it's not supposed to be an outcome-based judiciary. It works on laws. Now, we do know that the Supreme Court overturns precedent when they feel it's necessary to do so, and they could overturn the precedent that I've already argued. But they are still going to look at the legal challenges, the timeline issue, the rescission issue, the certification issue, the OLC opinion, and the political doctrine question. And so we're sitting here looking at saying what Ruth Bader Ginsburg, to go back to what she talked about, her argument is, how long is this going to be tied up in the courts? And would it be has the political landscape in our country changed enough to support a new equal rights amendment? After all, if any of you have watched the Mrs. America with Phyllis Schlafly about the whole argument, the button that they wore was stop the ERA, which meant stop taking our privileges. And ultimately, they argued that the institution of marriage would be undermined, traditional marriage would be out the door, women would lose children in the divorce if men had a chance, women would be drafted, women would no longer be protected by men or in the workplace. And we have laws now that have taken care of so many of those things. Well, first of all, we don't have a draft, but women are in the military. I did divorce law. Men and women have equal shots of getting custody of their children. We now have gay marriage that has been at the federal level. The institution of marriage hasn't been undermined. And so we really do have a different political landscape from 1972. And I don't believe that Ruth Bader Ginsburg thinks that this was a technicality. I think she knows the law better than all of us. And she basically is saying, I think the hurdles that will take years would be better served if we start now with a landscape that looks very different politically, and that we could get a new ERA in faster than we can through fighting the old one.
Well, I certainly didn't want to turn this into necessarily a debate, but I know that we have a number of people who probably have some thoughts or questions for both of our speakers, and we can use the last 10 minutes or so of the program for those questions. Maybe you have some thoughts as to whether we should pass the ERA, today, or whether you think that Ruth Bader Ginsburg, maybe we should start all over, or you might just have some questions. So if you do have questions, you can type them into the chat box, and I can read them to our speakers. If you want to say your question, please raise your hand, and I will have Georgiana or tell me if somebody has their hand raised.
Joy, we do have a question from Cindy Carter.
Okay, Cindy. So Cindy, please unmute yourself before you ask your question. And you might have to invite Cindy to unmute herself. I think that's an issue. Okay, so try again. Oh, I'm sorry, we can't hear you, Cindy, because you're still muted. So let me, Carolyn has a question.
I'm here.
All right, Cindy, go ahead.
I would just like to know, I really think you should never give up a game. If we started over, because I firmly believe that Trump is going to win again, I don't think this ERA amendment would go with his administration anywhere but under the carpet, and that's where it would stay. I just can't even imagine the thought of starting over. I just can't.
All right, thank you, Cindy. I'm going to ask Janette to unmute herself, because I did want to ask her how optimistic she was that we would have an ERA sooner rather than later. So again, we need to invite Janette to unmute herself in order for her to unmute herself.
Okay, great. Thank you. I do think that the power of the women's movement and the power of women in the legal field, in the executive branch, in Congress, bodes very well for progress on the existing ERA. I know that Supreme Court appointments can be lifetime appointments, but I think public pressure can steer the court in the way that would be ethical and just to provide the Equal Rights Amendment as an approved amendment. So I have a lot of hope. I don't think we should give up the existing ERA at all right now. And again, the OLC can work to our advantage depending who's in it. So a lot of us in the movement, we aren't wedded to one way that this gets approved. We'll take it however it's approved, and we will keep pushing for all those ways. And I do think within a couple of years, we'll probably know how far we're getting. Now, if certain states, if Congress would be willing to pass another amendment, there's been proposals in the Senate to do just that, to start over. Carolyn Maloney had introduced that one. Jackie Spear was carrying the existing one, but that didn't move forward in Congress either, because they are very, very determined to allow the current ERA to move forward. And with the new OLC and a new Supreme Court that maybe says, if we have others on the court that say this is in our jurisdiction and it goes back to Congress, great for us. We might have the majorities to make it a reality. So I don't think our BG should have weighed in this early when a lot was still happening with these cases and new administrations. We've seen with the midterms so much movement on electing people that do support it. So I don't think Congress is ready to start over yet, and they're going to be fighting for this as hard as they can until it looks really hard to do. I don't think they're going to pass the start over amendment.
We have Myra, who says we should do both, start over and fight in the courts for the current version. Joan, give us your estimate as to how long this, the current version will be fought in the courts.
Well, it's hard to predict. I mean, we are now at the first district court, and what happens often from a legal point of view is that this is now filed in one district court. Other states can file in their district courts, and when there are different decisions coming out of district courts, that's often when the Supreme Court will end up taking the case to kind of get some kind of continuity. I just would like to respond to Cindy with the idea that, I would love to have this one right now. Believe me, my position is, having been in the trenches working, defending women, I would love to have ERA right now. I am very realistic, though, about the possibility that this literally could go on for years. But if there were a new push for a new Equal Rights Amendment, and it were done within the timeline, then whoever is president is not relevant. The administration will not be relevant at that point. It's only become relevant because the archivist went to the Department of Justice to get the OLC memo. But if in fact this had all been done in the 7 years or the extension of the 3 years, it would have been done. There is no discretion on that with the archivist, and he would have had to certify it, and it would have been a constitutional amendment. So this isn't dependent on who wins the presidential election.
What about, we have Carolyn who says, would starting over offer a new deadline? She had more to say, but for time purposes, Joan first, because the whole thing about having a deadline to begin with is, some people have questioned whether that was constitutional.
I can answer that. In 1960, Congress started inserting the 7-year deadline with the 23rd Amendment, and then and they were putting it in the proposing resolution, the introduction to the text, and it was on the 24th and the 25th Amendment and the 26th Amendment and then the 27th Amendment. So there's the continuity of the fact that, yes, the deadlines are now pretty pro forma. They are in there, and almost all I went through all the amendments, and they were almost all passed within 2 years. Every amendment that we have was passed within 2 years. This was the one that had, even with a 7-year deadline, they usually get done in 2 years, 2.5 years. So, except for that one.
To say?
I was going to say, I think Congress has learned its lesson when it comes to the ERA and other amendments, that deadlines are not necessary, and they can often be a huge, huge hindrance. So if Congress does pass another ERA resolution, I am almost 99% sure they will not include any deadline at all. There's no, just because it was habit in the past, I think they learned their lesson, and I don't think they would ever do that again.
If I might just respond to that, the history is, though, that since 1960, they are putting deadlines in. And while that's an argument against it, it's been part of the procedure that they now put the deadlines in.
But the resolution that Congress just passed to lift the deadline shows they don't believe there should be a deadline. It was just passed in the House. So of course they're going to use that reasoning again if they do start over. They've already shown by passing Res 79 this year that they don't want a deadline on the ERA.
Well, we are at 8 o'clock, which is when we said we would end, but I have permission to go slightly over. Pat, were you trying to tell me that somebody else had a question?
Yes, there's somebody who's labeled iPad on my...
Oh, that's me. I have to change that. That's right. It's me, Gloria. Can I just say one thing? Of course, I was around when the original ERA was being promoted, et cetera, et cetera. And I agree with Joan. A lot has changed since then. And it seems to me to spend our time and energies on something that's probably fruitless to begin with, and it's going to take years and years. We do have other laws on the books now, and it seems like we could spend some of our time making sure that they're enforced and making sure that that women get the laws that are already there properly applied to them. And the same thing with the idea of the police and the idea of all these other things. There are laws there that are supposed to be helping women. So I could see, maybe starting over, doing a new thing, but to sap our energies for something that probably isn't going to happen, having been through the first one, I think is a mistake.
Well, Janette, let me have you respond to that first, and as we kind of wrap up here. So, what's your response to that, and your concluding remarks?
Well, I was a little confused if she meant we shouldn't keep pushing for the existing ERA, or we shouldn't waste our time starting over. I needed a little
I believe
clarity.
that she was saying that we shouldn't waste our time waiting for the courts to resolve this. I thought that's...
Oh, okay. Well, I don't agree that it's going to be years and years and years. This is the most pressing issue for the populace besides climate change right now. It's one of the top women's issues. And again, the women's voting bloc is huge and only growing. So I don't think it's going to be years and years. I think opinions will be forced sooner than later. And once the Supreme Court rules, that will be held up for quite a while. So let's get the Supreme Court to rule if need be. I'd rather they simply not judge and give it to Congress. But there's always going to be lawsuits against the laws, against an amendment. We need to keep pushing on the existing ERA. We're so close. And to give up now and to just say that the law won't be on our side, I don't think that's true. I think the time for the reality of equality is here.
And I'm going to give Janette the last word, if that's okay with you, Joan, unless you had a final remark.
I was just going to say that if we were arguing policy, there's no doubt that we should stay with what we have. But I have so much respect for Justice Ginsburg and her years of being in the law that I think she knows of what she speaks. And it does concern me knowing exactly how the courts work.
All right. I want to thank you both for being with us and for giving us your expertise and your time and your experiences. And I want to thank everybody who has joined us for the ERA today. Again, this session will be posted on the League of Women Voters of Dane County's website if you missed any of it. So thanks for being here. Our next forum is going to be on September 22nd at 7 p.m. It's about how we can ensure a safe, secure, and accessible November election. We're going to be talking about voter registration issues and absentee ballot issues and get out the vote efforts and a lot more. So I hope that we will see you then. Registration information is on the League of Women Voters of Dane County's website. Thanks and good night.
Thank you, everyone. Good night.